Kenya Independent Commission's Workers Union, number 38.
Yes.
Seeking leave to be adjoined as an interested party.
You are Mr. Who?
Jeru Kanyama.
Jeru
Kanyama.
Kanyamba.
Yes.
Secretary General.
He called me and I took instructions, and that's how I was able to receive this document from Mr. Wandabwa. It follows then, my lord, that I would need time to put in papers, and in the matter of what Mr. Wandabwa is addressing you on, then maybe we can come to it, because at this point I have not.
After hearing from
Yes.
you, will give directions.
We'll give directions.
So you require time.
I require
How
time.
much time?
I require 7 days, Your Lordship.
For time to put in our responses. We are praying for 7 days.
Their responses, my lord, I have no difficulty.
Conservatory orders. In lieu thereof, the court directs that the application petition be heard and determined on an expedited basis. Orders as to filing of responses to be agreed and or issued herewith.
Would you grant permission, my lord?
My lord, if it were a petition,
Will that lengthen the time?
Again, my lord, that is the difficulty that
Of which organization you say?
Kenya Independent Commission's Workers Union.
first.
Officer of the Independent Electoral and Boundaries Commission, 7th respondent. On 12th April 2018, the applicant filed a petition alleging contravention of several provisions of the Constitution and its fundamental rights and freedoms. Accompanying the petition was a motion under certificate of urgency seeking orders B, pending the inter partes hearing and determination of this application, a preservatory conservatory order be issued in the first instance, restraining the respondents by themselves or their servants, agents, or otherwise, howsoever, from implementing or enforcing the purported decision made on the 6th of April 2018, purporting to send the petitioner applicant on compulsory leave as contained in the internal memo dated the 6th of April 2018. C, pending the hearing and determination of this application, a preservatory conservatory order be issued in the first instance, restraining the respondents by themselves, servants, agents, or otherwise howsoever, from interfering with, stopping, blocking the petitioner applicant from resuming his employment forthwith, and from hindering him from carrying out his functions in furtherance of the purported compulsory leave contained in its memo dated the 6th April 2018. D, directions be given as to the early inter partes date of prayers E to I herein below. When the application was placed before the court on 12th April 2018, the court had brief oral submissions from Mr. Wandabwa for the applicant and certified it urgent. The court notes that it has considered those submissions made yesterday in this ruling. The applicant was directed to serve the respondents to appear in court today so that directions could be given. When the application was called out this morning, Ms. Tagetonga and Ms. Anyango appeared for the 2nd, 5th, and 6th respondents. They asked for 7 days to file their responses to the application. Ms. Awor, for the 7th respondent, also sought 7 days to file appropriate responses. The 1st, 3rd, and 4th respondents were not in court as they were stated to be out of Nairobi. Mr. Njeru Kanyamba, Secretary General of the Kenya Independent Commission Workers Union, also appeared and made an oral application to have the union enjoined in the petition as an interested party. The court directed him to file a formal application. In light of the requests by the present respondents for more time, Mr. Wandabwa urged the court to grant interim preservatory orders. In an effort to persuade the court to grant the interim preservatory orders, Mr. Wandabwa submitted that the seventh respondent's human resources and administration policies and procedures manual did not envisage compulsory leave, and that the sending of the applicant on such leave was disguised suspension without compliance with contractual agreements as contemplated by the Human Resources and Administration Policies and Procedures Manual. On legal anchor to the interim preservatory orders, Mr. Wandabwa urged that the second schedule to the Independent Electoral and Boundaries Commission Act provided that a decision of the seventh respondent could only be validly made when there was a quorum of 5 commissioners. It was also submitted that compulsory leave was akin to a removal from office without due process. According to Mr. Wandabwa, the meeting where the decision to send the applicant on compulsory leave was taken did not have the requisite quorum. The interest of justice, the court was informed, tilted in favor of granting ex parte interim orders. Otherwise, if the litigation were left to run its ordinary course, the applicant would have served and completed the 3 months compulsory leave, rendering the proceedings academic or moot. The dispute presented to court reveals a complex clash between the powers of an employer as an employer under the common law and constitutional and statutory protections afforded public officers in this jurisdiction. Ordinarily, under the common law, the obligation of the employer is to pay wages and all salaries and not to provide work. However, it has long been recognized under the common law that suspension of an employee with or without pay would be in breach of contract.